Welcome to this special broadcast of the opening session of the Arms Procurement Commission taking place here at the Semi Marks Square building in the center of Pretoria. We will be bringing you the proceedings of that commission. Commission Chairperson Judge Willie Seriti will be making some opening remarks at about 10 o'clock, 10 o'clock on the dot. We've been told thereafter the evidence leader will be taking us through what is going to happen in this first session of the Arms Deal Procurement Commission. But before we get there, we're going to take a look. We're going to go back into time and bring you some of the issues the people have raised over the years, the rationale behind the whole arms deal as through the comments that were made by then ministers who were in charge or integrally involved in this procurement process, the explanations they gave the nation back then. We're going to go back to how and why this commission was set up, also the rationale behind that, President Jacob Zuma's appointment of Judge Seriti. We'll bring you all those issues and more over the next half an hour or so. Everyone is here who is expected or who was expected to come today. All of that, of course, happening amidst allegations, resignations, and all manner of things that have preceded this commission. In other words, the commission really, over the past few days especially, being in the news, but for all the wrong reasons. So we'll bring you all of that, the state of readiness, and everything that has happened. For now, though, let's take a very brief look into the state of readiness. Njanje Chauke prepared this inset for us.
This is the venue. Initially to be headed by 3 judges, these chairs are likely to be occupied by only 2. It follows the resignation of one of 3 commissioners, Judge Francis Likhodi. 2 other leading members, including a top investigator, earlier jumped ship. The commission's been charged with investigating, amongst others, the rationale for acquiring arms, the offsets, how many jobs the contract created, and if the equipment is being used.
There is also the issue of the finances. In terms of reference 5 and 6 are then talking about if there were any due influence by any other person, whether a politician or an official or an institution, and also whether there were elements of corruption.
Investigators went abroad to source information. A string of witnesses will be called.
We are calling on the Defense Force and military veterans, where we have officials from the Navy, officials from the Air Force, and DINEL has still to send us a number of the names of the officials.
Whistleblowers end of the list of witnesses. They include Patricia de Lille, now Cape Town Mayor. The commission has been allocated a 40 million rand budget, but due to the delays and its possible extension, the costs are likely to escalate. Njanje Chauke, SABC News, Semi Marks Square, Pretoria.
But if you've just joined us, you're watching a live broadcast of the first session of the Arms Procurement Commission set up by President Jacob Zuma to look into the whole arms deal, what really happened back then, the rationale behind the arms deal purchase, and indeed whether we are getting everything that we were promised in terms of the offsets and everything around the arms deal. For now, though, we're going to go back into time to talk, to play for you some of the comments that were made by the people who were responsible for this arms deal procurement back then. As we are waiting for Judge Willie Seriti, the chairperson of the commission, to make the much-awaited opening of these hearings. But for now, we're going to take you back to 2001. The then minister, the late Minister of Defense, who appearing before Scopa in Parliament. There were hearings at the time on charges that were leveled against the government, that they were in fact in dereliction of duty when they are approved of the arms deal. The then Minister of Trade and Industry, Alec Erwin, who was with him, said the deal was indeed approved through correct processes. Let's just hear briefly what the minister had to say back then.
Paper on defense in a democracy, was approved by Parliament in 1996. The White Paper on Defense follows on from the Constitution, which states that the SANDF's primary objective is the defense and protection of the Republic, its territorial integrity, and its people. Following on from the White Paper on Defense, a more detailed defense review was approved by Cabinet during 1998. The defense review indicates, amongst others, the core capability requirements for the execution of the identified tasks of the South African National Defence Force. These 7 core capabilities, which are required, include inter alia, surface combat, submarine, combat air transport, airspace control, armor, air defense and anti-armor. In order to provide for the required capabilities, 14 major equipment systems were identified. A number of the systems which are required for purposes of maintaining the identified core capabilities are in dire need of replacement due to block obsolescence. In order to timelessly initiate the acquisition of the foreign systems, requests for information on the required systems were submitted to 11 countries during September 1997, following which 37 responses were received from 9 countries during October 1997. The responses were evaluated against predetermined value systems by the Department of Defense and Arms Corps, and a short list of possible suppliers from 7 different countries was recommended to and approved by the Armaments Acquisition Council during January 1998.
The late former Minister of Defense, they're talking, of course, about that arms deal and the rationale behind it. Well, another person who was also involved was, of course, the Minister of Trade and Industry at the time, Alec Erwin, who also rose to the defense of this arms procurement deal. This is what Alec Erwin had to say back in 2001.
To purchase the equipment emanated from the Defence Review, a decision taken in this Parliament and executed by the Cabinet to procure the defence equipment. We also then make the point that the process for making this purchase was characterized by some important new features of decision-making, particularly in regard to arms. The decision to put the requirements into a total package, despite the fact that they stretched over a number of years, and deal with them as a comprehensive strategic procurement and not allow them to be dealt with year on year as distinct items of equipment as the requirements were made. This means, and I think an important point, this means that 4 departments and 4 ministers were immediately involved, and we were chaired by the then Deputy President, subsequently President Thabo Mbeki. this means that the evaluation process, which was examined by the Auditor General and in the questioning of Scopa, is not identical to the decision-making process. The decision-making process was informed by that evaluation, but the decisions were taken by a Cabinet subcommittee making recommendations to the Cabinet. This is important from our viewpoint because it means that we had structured the process in a manner that meant that many players were involved in the decision, and this was done explicitly to ensure that we could manage this decision in the optimal manner. We were highly conscious of the magnitude of this expenditure, and accordingly the important decision made at the outset was that we would deal with the procurement in phases. That was, we took a decision to purchase equipment, provided that it was within the realm of affordability, and these exercises then commenced to establish that through process of bidding and ongoing assessment by Cabinet at different stages as to whether we were meeting these two objectives, the objective of re-equipping the South African National Defence Force and the objective of ensuring affordability.
Former Trade and Industry Minister Alec Erwin vouching for that process, which of course led to the purchase of arms in what is now commonly known as the infamous arms deal. Well, when then questions started being asked about this commission, there was a lot of resistance initially from the government as to whether in fact they needed to explain more, or whether in fact they needed to be an inquiry into the whole arms deal. But eventually President Jacob Zuma then decided that indeed this inquiry must take place. Let's hear what the reasons were and why this commission was set up.
Well, it is a worry, I must say. I did not expect it, particularly this time. I think in terms of the report, that commission very soon will be beginning its hearings. I think it is unfortunate. I was able to have an audience with the judge, as well as the chairperson, in fact, all members of the commission. The judge said he has made up his mind for personal reasons. And it was clear he has made up his mind. And of course, once that happens, and then if the judge says, look, these are personal reasons why I'm going away, I don't think you could prevail in any other way. That remains the issue, and I'm hoping that the remaining commissioners will be able to do the job.
So you won't appoint another commissioner?
Well, that is, I've not decided that as yet, because I've got to look, after the resignation has taken place, we'll have to look into that. The reason why I can't necessarily say now what's going to happen is because a lot of work had been taken place. They're about to start. A new person will have to start, and that person will have to begin to climatize himself or herself over the period. That might impact on when the commission begins. That those are the kind of issues we're going to be looking at.
So when we read the papers and some of the comments that have been made, the leadership style of Judge Siriti has been brought to the fore. Is that a concern for you, or is this something that you've just put to one side?
Well, if for an example, the judge who has resigned, if those were the issues, because those were the issues that we'll have to deal with. But he said he was resigning on personal reasons. So you couldn't tackle the issue that has not been brought forward as an issue to say, look, here is a problem. Because I'm sure if that was a problem, there could have been a problem that we could have talked about at some point, if at all there were accusations, to look at them, etc., etc.
President Jacob Zuma speaking to our colleagues Peter Ndoro and Vabakshini Chetty on the resignation of Judge Khodi, but also the events that have taken place over the past few days, which indeed attracted some bad publicity for the commission, an issue that we understand the judge will be addressing in his opening remarks at around 10 o'clock. Well, inside, everyone is ready, waiting for the judge to appear and address the people who will be gathered here for the very opening of this Arms Procurement Commission, the first day of the public hearings into this question. An issue that has been with us as a country for a very, very long time indeed, until, of course, President Jacob Zuma decided that it is indeed in the interest of the country as a whole to actually find out as much as we can about what happened, the rationale behind the purchase of arms, but also whether in fact there was any corruption involved, and whether there is information out there that links other people to wrongdoing. And if that is the case, including broken promises, then we should decide as a nation as to what to do next. Well, one of the people who were integrally involved, a lot of people refer to her as the initial whistleblower, is Patricia de Lille. Patricia de Lille went to Parliament and actually raised several issues around the arms deal. Now, a lot has happened since, leading to the prosecution and conviction of some individuals. I spoke to her last night. I started by asking her just how she felt now that the commission was indeed taking place, but also some other issues that she wanted to raise, issues that have come to the fore that are in the public domain now, including the resignations, but also including the fact that some people cannot afford lawyers and who can actually come and represent them here. And these are people who may want to give evidence before the commission about those and more issues. I spoke to her last night, and here, this is what she had to say.
Us who have to go and give evidence to the Arms Deal Commission must pay for our own legal costs. Similar like Marikana. We have to pay. I don't mind paying because I can afford it, but there might be other people who cannot afford to pay for lawyers to assist them to go and lead evidence at the commission. So the commission must now already begin to talk about people that cannot afford to come and lead evidence. In my case, Vuyo, when I went to Parliament with a document that is now called the de Lille dossier, it's information that I received from concerned members of the ANC, and I took that information to Parliament, and I called on President Thabo Mbeki at the time to establish a commission of inquiry. Now, the allegations contained in the de Lille dossier led to two successful prosecutions. The one is Shabir Sheikh, and the other one is Tony Ngeni. And so, therefore, me going to the commission will still be to appeal to the commission to investigate this information that was handed to me, because I am sure that many more people can be prosecuted arising out of the allegations contained in the de Lille dossier.
The Mayor of Cape Town, Patricia de Lille, talking to me last night. Well, alongside Patricia de Lille is a gentleman called Terry Crawford Brown. He is one of the people who have been at pains trying to convince people inside and outside of the state of the need for this commission of inquiry. Well, I spoke to him this morning just about how he felt now that we are on the first day today, where the South Africa as a whole is going to listen through the evidence that people will be bringing before this commission as the public hearings get underway today. Here's how our discussion went this morning.
time since the 1996 to 1998 Defence Review in Parliament. And in 1999, Archbishop Ndungane first called for an investigation, and there's been huge efforts to cover up the scandal. Books have been written, and up until 2010, the response from government was there was no case to answer. Finally, in 2010, they admitted there was a mountain of evidence of corruption, 460 boxes and 4.7 million computer pages of evidence just against BAE alone, let alone the German frigate and German submarine consortium. So there's a mountain of evidence. Books have been written. It's been a long, long time in coming. But I do think also the climate has changed internationally, that whereas in the 90s it was not illegal in English law to bribe foreigners, and in Germany bribes were even tax deductible as a useful business expense, the pendulum has swung internationally, and of course thanks to the internet, thanks to the media, there's much, much more exposure on issues of corruption which are now deemed to be a very serious security matter.
Now, it's a question you've probably been asked before. What made you feel so that it is so necessary for you to actually follow this process, to be consistent, to be persistent? What drove you to actually really lead this campaign?
Well, I was appointed by Archbishop Ndungane to represent the Anglican Church at the Defence Review. And our stance was there was no conceivable foreign threat to South Africa. The threat was poverty. That as a consequence of the apartheid era, the legacies of the apartheid era, education, health, job creation, housing, those were the priorities, not buying weapons against a non-existent foreign enemy. And when the armaments industry and Arms Corps and the Department of Trade and Industry dressed it up with the absurdity that if we spent 30 billion rand on warships and warplanes, the European armaments industry would invest back 110 billion in offsets that would create 65,000 jobs. My banking background said this is just an invitation to corruption. And very soon the evidence flowed of bribes being laundered through Swedish trade unions to ANC politicians. And when I got confirmation from Sweden, I asked through contacts in London, asked the British government to investigate. Scotland Yard was appointed, and it came back it was not illegal in English law in 1998, 1999 to bribe foreigners. And so that then led to eventually whistleblowers approaching me, and they said the arms deal is really just the tip of the iceberg. It's much, much bigger than the arms deal. It's oil deals, it's Cell C, it's driver's licenses, it's Kucha, it's diamond deals, it's drug deals, and it's money laundering. And the common denominator to this is 10% kickback to the ANC for political protection. So it was on a scale much, much bigger than I was talking about. And why, sadly, there has been these attempts to cover up the scandal, and in the process have only compounded the problems.
Now, a lot of the information is out there in the public domain. I mean, the prosecutions that have happened as a result, the matter of like Tony Yengeni and so on. Is there new information that you're planning to put before the Commission, apart from the stuff that we know about already or that has been reported on and the fallouts that we've seen? Is there new stuff that you'll be bringing to the attention of the Commission?
Well, I've made two submissions, written submissions to the Commission in June 2012 and December 2012. And there are 6 terms of reference that the Commission was required to investigate, and 3 of those deal with offsets. So the first issue is the rationale. The rationale was you spend 30 billion on armaments, you'll get 110 billion back, and that'll create 65,000 jobs. That has been totally discredited now. We didn't get the jobs, we didn't get the technology. But my argument is that it fails Section 217 of the Constitution, which require government procurements to be conducted in accordance with the system, which is open, transparent, competitive and cost-effective. It clearly failed that. And therefore the arms deal was unconstitutional, illegal and fraudulent right from inception. It's unfixable, it's fraudulent, and the international remedy for fraud is to cancel the contracts, return the equipment and to recover the money. Now, we haven't in fact yet paid for the arms deal. We've borrowed money. in the case of the BAE contracts, we borrowed from Barclays Bank until 2019. And so that issue needs to be really investigated. And that is really the sixth term of reference. What would be the consequences of cancellation of those contracts? Because the contracts are guaranteed by the British and the German governments, and I would suggest that they are the ones who should be questioned as to why they put massive pressure on our government to buy weapons they knew we didn't need and could not afford when we had so many other social priorities that were far more pressing.
Now, among the concerns that you have is the fact that the ANC has not been subpoenaed, and indications at this stage are that it won't be subpoenaed. Why do you feel so strongly that the ANC should be subpoenaed?
Well, amongst the documents I submitted to the Constitutional Court were 160 pages of affidavits from the Serious Fraud Office in England and the old Scorpions here that detail how and why BAE paid bribes of £115 million, let's say 1.5 billion rand, who those bribes were paid to and which bank accounts were credited. And the primary recipient of those bribes was Fana Shlangwana, who was the assistant to Joe Modise. And the others were simply bagmen who would find conduits to fund the ANC. You'll recall that in March 2010, the National Prosecuting Authority refused to seize an estimated 200 million rands worth of bribes that had been paid to Fana Shlangwana by BAE into accounts in Liechtenstein. The judge involved was so astounded that the National Prosecuting Authority refused to seize those funds that he put about 500 pages of documents into the public register. So the issue is why the cover-up, why it only compounds the issues. I think the major fault lies in the pressure that was put on our government to buy weapons we didn't need, and that, of course, internationally, the armaments industry is notoriously corrupt. It's noted for corruption, but how do you fund political parties except by kickbacks from arms deals?
Well, that's how my conversation with Terry Crawford Brown went this morning. Well, in 2011, the Minister of Justice and Constitutional Development, Jeff Radebe, announced the comprehensive terms of reference of this commission, whose public hearings are getting underway in a few minutes' time. He gave assurances that the commission would work independently of everyone, including the executive. And here is how he went about making that announcement.
The regulations, amongst others, gives the commission the power to subpoena witnesses, to compel witnesses to answer questions, the power of search and seizure.
The terms of reference of the Commission deal with the criminal aspects of corruption. Corruption is a crime. And also with the civil law aspects. If a contract, and these arms deals are all contracts, is tainted by corruption or by fraud, then it is open to the South African government on these facts to cancel the deal on the basis of the fraud or corruption. And that means giving back the arms that were bought and getting back the money that was paid. And ironically, the money that was paid includes the bribes that were given to middlemen and commission agents and possibly crooked civil servants and politicians.
Watching a live broadcast of the opening session of the Arms Deal Procurement Commission taking place here at the Semi Marks Square building in the center of Pretoria. Well, joining me now is the chairperson, is the spokesperson of the commission, Mr. Baloyi. Welcome to this special broadcast.
Morning, and thank you very much, and morning to the viewers.
Thanks for joining us. In a few minutes, we're expecting Judge Willie Seriti, the chairperson of the commission, to address this gathering.
Definitely, it's all systems go. The chairperson would be giving an open address in a few minutes, as if we've indicated from now, and thereafter, the evidence leaders would outline the process forward. But let me indicate something very important for you, is that during the sitting, remember the different representatives, legal representatives or members of the public are allowed to raise issues. So when it might happen that a member of the public might raise a certain issue that needs the attention of the Commission, and that is allowed. That is the transparency of the Commission.
Now, are they going to raise procedural issues or substantive issues of any kind? Can you just clarify, what are the parameters, in other words, for anyone who intends or may want to raise an issue here this morning?
Firstly, the members of the public, including institutions and individuals, can submit whatever motion that they can submit that will look and entertain it or kick it out. But secondly, the evidence leaders will be talking about the process itself. So there might be questions of procedural issues or clarity-seeking questions that might be raised, and that it's proper.
Now, I mean, over the past few days, there were people calling for either a postponement, others calling for the resignation of the judge, arguing that the incidents of the past few days and months has actually made it difficult for the Commission to proceed with the sort of integrity that it deserves. Can someone put that issue on the table here this morning, hypothetically at least?
By law, it will be within the rights for a person to submit a request for recusal. And normally that request, it's entertained, we looked at it, and then we take it from there on. So it's normal processes that go, as it also happens in a normal process of court.
But from the Commission's point of view, in other words, the level and state of readiness, you are confident that if there is no major issue, you will be able to proceed?
We did our consultations with the witnesses. We have engaged with their representatives. Logistically, we are ready. Procedurally, we are ready. But obviously, anything can be raised. But for now, we are ready to proceed.
And the issue of Judge Lekhodi, how is that at all going to impact on the Commission, given that there hasn't as yet, I mean, the resignation was sudden, it happened a few days ago. Is there someone who has been earmarked to take his place, or how is it, or is it not a matter at all at this stage?
The resignation of Judge Lekhodi is a regrettable thing. However, the issue of his replacement or non-replacement is an issue that lies with the presidency, and I think we'll get an advisory in that respect. And maybe the chairperson might touch it when we begin.
Now, this being phase one, just take us through again very briefly around what's going to happen this time, or what is supposed to happen this time around in this phase of the public hearings.
Phase one of the public hearings, we are looking at terms of reference number 1, number 2, terms of reference of saying the rationale behind the acquisition of this package, to whether the arsenals are being utilized or underutilized. So that is where we'll be focusing. That's why we have now the Department of Defense, both the Navy and the Army, that will be outlining that. And we'll also, at the last tail, we're going to put on the issue of the offsets, whether the offsets as promised have been realized, whether the jobs that were promised have they been realized. If not, why not? So that will be occupation for this first phase.
Okay. Beyond first phase, what then happens next?
That one, I might not comment on it, as you might be aware that our time ends in November. So we have applied for a 12-month extension from the presidency. So when they respond to us positively, then we'll outline the following phases.
Any indication as yet as to when we might expect the presidency to respond?
I think the presidency released a statement to say that the president is still applying his mind on that one, and we'll let it as such.
But no date yet as to by such and such a time we'll be able to give you an answer?
Not as far as I know.
Well, the spokesperson of the Arms Deal Commission with us here, Mr. Baloyi, talking about how we are going to proceed. Well, the Commission hasn't started as yet, but we are expecting Judge Seriti, who is the chairperson of the Commission, to walk in any time from now and take us through what is going to happen. For now, though, we're going to take a quick commercial break. We'll be back.
SABC News. We report, contextualize and present news and current affairs honestly, fairly and fully. We consider it a duty to provide consistent, relevant, useful and top quality information and analysis. Our mission is to provide credible, accurate and interesting news programming, bringing news into everyone's homes in everyone's languages. Thank you, South Africa, for relying on SABC News for quality news output and for making us your #1 source of information. SABC News, Africa's news leader.
Are we taking the teaser on this?
For decades, the SABC has provided a ringside seat
for the events that have made history in South Africa and across the globe.
The SABC has opened a window on our world.
We talk to people making the news,
so you can make sense of events
in your preferred language
and moments in history that truly changed the world.
Whenever news happens, you are there
because SABC News is there
when you want it.
Our news gathering draws from the SABC's extensive network across the globe.
At the heart of it all is this state-of-the-art studio.
And from the sports field, all the interviews, color,
and in-depth analysis from around the world.
It's comprehensive.
It's trusted.
This is SABC News,
Africa's news leader.
Well, welcome back, and if you just joined us, you're watching a live broadcast of the opening session of the Arms Deal Commission taking place here at the Semi Marks Square in the center of Pretoria. Well, Judge Willie Seriti, the chairperson of the commission, is expected to walk in any time from now and take us through what is going to happen. In his opening remarks, the judge is expected to talk about whether, as some people have suggested, that a few issues need to be ironed out before the commission can sit. But of course, there is also a lot of people who feel that because this commission is long overdue, any delays may just affect it. But then there are others who are raising the issue of the integrity of the commission, saying to proceed, having waited so long, everything needs to be done to ensure that the credibility and the integrity of the commission is not affected. So we are going to hear from the judge as to whether they have considered any of the suggestions that have been made, and whether and how, in fact, the commission intends to proceed from this point on. But there are indications that some consideration is indeed being given to some of the concerns that have been raised, but also the issues that have happened over the past few days, including the resignation of Judge Lekhodi. But we don't know as yet as to whether this may even mean a postponement. We are waiting for Judge Seriti to walk into that into the podium there and begin to address the commission.
SABC News. We report, contextualize and present news and current affairs honestly, fairly and fully. We consider it a duty to provide consistent, relevant, useful and top quality information and analysis. Our mission is to provide credible, accurate and interesting news programming, bringing news into everyone's homes in everyone's languages. Thank you, South Africa, for relying on SABC News for quality news output and for making us your #1 source of information. SABC News, Africa's news leader. Why watch the news on SABC? We bring you news in your own language. News that affect you. Sports. We have
Catherine Drew, SABC News at the High Court in London.
Shervin Bryce-Pease, SABC News.
Sarah Kimani, SABC News, Nairobi.
We touch and change people's lives. SABC News, Africa's news leader. Get all the latest news from the SABC's online news services on our website. Breaking news and in-depth coverage of everything from business, sports to politics and lifestyle. Catch the top news clips and watch live streaming of major news events on the SABC News YouTube channel whenever. Stay connected on the SABC News Facebook page and have your say on news that matters to you. And for the latest headlines and live updates from our reporters, follow us on Twitter. SABC Digital News, anytime, anywhere.
SABC News coming to you live from Johannesburg, South Africa. It's just gone 10:15, a little bit later this morning because of the Arms Procurement Commission, but we have our news headlines for you. The Commission of Inquiry into the multi-billion rand arms deal gets underway in Pretoria. Somali peacekeepers wants the country's security to take control of key points of entry. And Orlando Pirates thumps Egypt's Al Ahly in the African Champions League competition. Details of those stories. The Commission of Inquiry into the multi-billion rand arms deal begins with public hearings in Pretoria today. Former President Thabo Mbeki, Planning Minister Trevor Manuel, and former Ministers Masiwa Lekota, Ronnie Castrals and Alec Irwin are all expected to be called to testify.
A song of hope, a plea for peace. A day after President Mugabe delivered a crushing defeat to the opposition, extending his 33 years in power. Church leaders have urged dialogue between the victors and the defeated, and much is expected from ZANU-PF.
I expect them to deal with issues that have been problematic to us as the church. Issues of corruption and cronyism and irresponsibility.
Is the venue. Initially to be headed by 3 judges, these chairs are likely to be occupied by only 2. It follows the resignation of one of 3 commissioners, Judge Francis Lkhodi. 2 other leading members, including a top investigator, earlier jumped ship. The commission's been charged with investigating, amongst others, the rationale for acquiring arms, the offsets, how many jobs the contract created, and if the equipment is being used.
There is also the issue of the finances. In terms of reference 5 and 6 are then talking about if there were any due influence by any other person, whether a politician or an official or an institution, and also whether there were elements of corruption.
Investigators went abroad to source information. A string of witnesses will be called.
We are calling on the Defence Force and military veterans, where we have officials from the Navy, officials from the Air Force, and Dinel has still to send us a number of, the names of the officials.
Whistleblowers end of the list of witnesses. They include Patricia de Lille, now Cape Town Mayor. The commission has been allocated a 40 million rand budget, but due to the delays and its possible extension, the costs are likely to escalate. Janji Chauke, SABC News, Semi-Mark Square, Pretoria.
Meanwhile, Cape Town Mayor Patricia de Lille has criticised the Arms Procurement Commission for asking witnesses to pay from their own pockets. De Lille is in the initial whistleblower on the procurement of arms and is expected to testify during the public hearings.
All of us who have to go and give evidence to the Arms Deal Commission must pay for our own legal costs. It's similar like Marikana. We have to pay. I don't mind paying because I can afford it, but there might be other people who cannot afford to pay for lawyers to assist them to go and lead evidence at the commission. So the commission must now already begin to talk about people that cannot afford to come and lead evidence. In my case, Vuyo, when I went to Parliament with a document that is now called the De Lille dossier, it's information that I received from concerned members of the ANC, and I took that information to Parliament and I called on President Thabo Mbeki at the time to establish a commission of inquiry. Now, the allegations contained in the De Lille dossier led to 2 successful prosecutions. The one is Shabir Sheikh and the other one is Tony Ngeni. And so therefore, me going to the commission will still be to appeal to the commission to investigate this information that was handed to me, because I am sure that many more people can be prosecuted arising out of the allegations contained in the De Lille dossier.
And we now cross back to the Arms Procurement Commission, Vuyo Mvuku, as we have a breaking story there. Vuyo.
Well, thanks very much, Loretta. We do indeed have some breaking news for you. We have just been reliably informed that the commission is indeed going to be postponed. As to why or which aspects of the issues and criticisms that have been raised, the judge has considered. We are yet to be told. Judge Seriti will come on any minute from now to tell us why exactly this commission is indeed going to be postponed. But we have been told that the commission is going to be postponed. As to by how many days or weeks, we're going to hear from the commission. But that's all I have for you. But the judge will be coming through any minute from now. Loretta, back to you.
Thank you, Vuyo. And we continue with our bulletin. Zimbabwe police have set up more roadblocks in Harare. Some are manned by officers with automatic rifles. The precautions come as church leaders urge people to pray for peace after disputed elections. Results gave President Robert Mugabe a landslide victory.
I remember lines, but you know, it's...
A day after President Mugabe delivered a crushing defeat to the opposition, extending his 33 years in power. Church leaders have urged dialogue between the victors and the defeated, and much is expected from ZANU-PF.
I expect them to deal with issues that have been problematic to us as the church. Issues of corruption and cronyism and irresponsibility in dispensing national duty.
It's not all gone. Let's continue to look at the issues relative to development of our country.
MDC leader Morgan Tsvangirai will challenge the results in court. The smaller MDC faction lost all its seats, but it will not be taking the matter further, saying it has no faith in the independence of the judiciary. It, however, made an impassioned plea to SADC and the African Union.
They should be able to do some introspection and say what are their standards for what they consider to be a free and fair election, because this is not just about Zimbabwe.
The poll has left the country divided. Some believe it's game over for now for the MDC, that it should now focus on renewing its leadership and work towards the 2018 elections. Shingai Nyoka, SABC News, Harare, Zimbabwe.
Meanwhile, President Jacob Zuma has congratulated Robert Mugabe on his re-election as president. Not everyone has endorsed Mugabe's lengthened presidency.
President Zuma commended the Zimbabwean people for
Paul, I think they need to run a strap saying there's a delay in the commission. Yeah, if you can tell, I think we should tell studio to do that, so that people are not confused, because we're talking about Zimbabwe, but we're at the arms deal, and yeah. What's happening? What's going on inside? Well, thank you very much and welcome back. Well, the Commission is about to start now. Judge Seriti has actually gone into the room and ready to explain why this commission is going to be postponed, as we told you a short while ago. Let's go straight inside.
Good morning, everybody. Firstly, let me introduce myself. My name is Willie Lehwabe Seriti. I'm the chairperson of the commission. And on my right-hand side is Judge President Musi, who is assisting me. I think before we start, I want to deal with one or two issues. Firstly, you will recall that on the 4th of November 2011, the President announced the setting up of a commission called the Commission which is supposed to inquire into allegations of fraud, corruption, impropriety or irregularity in the strategic defense procurement package. The terms of reference thereof were published on the 4th of November 2011. And again, during the same month, and again, on the 8th of February 2012, the regulations regulating the conduct of this inquiry were published by the President. And the regulations basically, to a very great extent, deals with issues relating to how the Commission should operate and how people who appear before the Commission is expected from them. After the Commission was established and regulations put in place, 3 people were nominated or appointed by the President as commissioners. I was appointed as the chairperson, and in terms of the applicable procedures, 2 people were appointed to assist me. That is Judge J.P. Musio, sitting on my right-hand side, and Judge Lehoji. After a lot of work had been done, and after our evidence leaders plowed through volumes and volumes of documentation, and after they consulted with various witnesses, a media statement was issued, which media statement announced that we will start with our public hearings on the 4th of March. But unfortunately, as times went on, we then realized that, or the evidence leaders realized that they are not as ready as they should be. They then addressed a memorandum to the commissioners asking that the commissioners should agree to the adjournment or the deferment of the starting of the proceedings. After I considered that memorandum together with my two co-commissioners, we agreed that probably it will be much better if the starting of the proceedings of this commission are deferred until the 5th of August, 2013. During that period, until sometime yesterday evening, we have been in touch with the evidence leaders. We have been pushing them very hard, making sure that come the 5th of August, they are all ready to lead the witnesses that have been allocated to them. 2-3 weeks ago, we were assured by the evidence leaders that they have consulted all the witnesses that they had to consult, which they think that are necessary to start with, particularly those witnesses whose evidence deals with the rationale of the entire procurement package. A list of witnesses was drawn up by the evidence leaders after they consulted with the top echelon of the South African Defence Force. The South African Defence Force gave the evidence leaders a long list of people who might possibly be in a position to assist the Commission to carry out its mandate. Our evidence leaders looked at that list, looked at other names of people that they always had in mind when went through the papers as possible witnesses. The evidence leaders then consulted with the names of people that they've been given by the Department of Defense and people whose names, or people who, in our evidence leaders' view, will be in a position to assist the Commission to carry out its mandate, were also consulted. After that consultation, evidence leaders then drew up a list of 11 people from the Defence Force. Another list was drawn of witnesses from the Department of Trade and Industry, and another list of people from National Treasury officials. On the 15th of July, we issued a media statement wherein we indicated that the Commission is going to start on the 5th of August, and we also indicated the names of people who the Commission feels that will be in a position to assist the Commission to carry out its mandate. I think I should emphasize that prior to releasing this list, our evidence leaders consulted with all those witnesses. And they gave us the names of those witnesses as potential witnesses because the evidence leaders were satisfied that these people will be in a position to help the Commission to carry out its mandate. And I think it's important for me to emphasize this point because we're trying to make sure that there's no confusion which might be caused by the fact that some of these government departments have now engaged their own private legal practitioners. We know that the Department of Defense has got several legal practitioners from outside, and the Department of Trade and Industry was made to understand that they also have engaged several legal practitioners from outside, and I think the same also applies to DTI. I think I need to make it very clear at the beginning that the witnesses that we have subpoenaed, those are the witnesses for the Commission. They are going to be led by the evidence leaders. The role that their legal representatives are going to play is going to be to assist their witnesses and not to lead them during the public hearings. If I understand the regulations very well, The role that the private legal practitioners or various witnesses might play is to assist them and, if possible, also re-examine if there's a need to. But those witnesses are witnesses identified by the evidence leaders, and they are duty-bound to come to give evidence once we've given them the subpoenas. Yesterday evening at about 8, 9, 10, I was at home, and the head of the legal research phoned me and said to me that there's an urgent application which most likely pending against the Commission. I was sent a draft of an application which was supposed to be brought in the North Gauteng High Court, Pretoria. In that application, or in the anticipated application, there were going to be possibly 2 applicants, the Minister of Defense and Military Veterans, and Rear Admiral Alan Green, who was going to be the second applicant. And the chairperson of the commission, that is myself, I was the first respondent. Musi JP on my right-hand side was the second respondent, and the President of the Republic of South Africa was going to be there, and I was going to be the third respondent. I went through the application together with the accompanying letter, and it turns out that the issues that the parties were raising in the document are issues that we have already considered. One of the issues that the applicants in these papers were going to raise, it was the question of the status of this commission in the light of the resignation of Judge Lukhodi. The applicants in this application, or in the intended application, correctly says is that once we remain only 2, then we are not co-rate, and therefore we cannot proceed or lawfully proceed with this inquiry. And the third point that they raised was that possibly for us to be in a position to proceed, the President must make up his mind one way or the other, either by, I think they call it a presidential minute, be clear that we can only proceed being 2, or if he so wishes, he must add the third person. One of the evidence leaders sent me a letter very late in the evening, and incidentally, the same issues that you raised, those were the issues that I had discussed with the JP the day before. But then you are spot on when you said that we do have a legal difficulty caused by the fact that one of the commissioners has resigned. The powers that be, or the President, I was made to understand, is in the process of attending to that difficulty. He was also aware of it. Apparently, the President is going to deal with that by way of the quality of presidential minute. And I was made to understand that that difficulty can be dealt with even before the end of this week. So, I think I must say to the legal representative of the Department of Defense that there's no need for you to bring the urgent application against me, because we are already there. One was made to understand that the President could not, we will need a bit of time in order to deal with the issue of whether there must be 2 or 3 people, or if it all is through who. And that time frame, I was made to understand that it will be 2 to 4 days. And I hope that by the end of this week, that would have been dealt with. Now, the other issue that I want to deal with is a question of the level of preparedness of our evidence leaders to proceed with this matter if Judge Lukhodi did not resign at the time at which he did. In other words, the question that I'm going to ask to the evidence leaders is whether were they prepared to start leading the witnesses of DOD that we have already subpoenaed. We remember that we have subpoenaed witnesses from DOD, DTI, and Treasury. But then before I do that, maybe let me ask Advocate Abu Baker to introduce his team.
Thank you, Mr. Chairman. I think it's appropriate at this stage that I place on record that I represent the team of evidence leaders. And my name is T.N. Abu Baker, and I'm a senior counsel from Durban. To the right of me, and I'm going to introduce people to the right first and then to the left, is Mr. Barry Skinner, SC from Durban. Next to him is Mr. Shepo Sebeko from Johannesburg. And next to him is Selo Mashlape from Johannesburg. And next to her is Carol Subia from Durban. And next to her is Swu Zondi from Pietermaritzburg. To my left is Advocate Pumlani Ngobese from Pretoria, Shwani. And next to him is Mrs. Ramapkaka, who's also from Shwani. And next to him is Mr. Moss Mpaga SC from Shwane. And next to him is Mr. Simi Labala. Mr. Chairman, we've heard the input made, and we are in full agreement that there are technical difficulties that have arisen which impact upon the hearing today. We can assure you that we are in a total state of preparedness to start with the hearings of the Commission, and perhaps it is appropriate if Mr. Chairman, you wish to hear from the person representing the DOD team, the Department of Defense team, Mr. Sibi Labala, as to that state of readiness.
Thank you. Advocate Labala, very briefly.
Members of the media, I do not know whether I have to recapitulate and start with my introduction, because when I started, the mic was not on. Chairperson Dr. Judge Siriti, Co-Commissioner Judge Musi, colleagues, fellow evidence leaders, members of the profession, distinguished colleagues representing different teams, members of the media, and all interest parties. On behalf of my distinguished colleagues, with our cap on as representing a team that has to lead the DOD team in as far as the first applicable relevant terms of reference of the commissions are concerned, we need to address the question whether are we ready to proceed. Are we ready to proceed to lead evidence? Underpinning this question is a question whether do the current developments affect our state of readiness. Permit me to say this with my head held high on behalf of our team. We are ready, more than ready. In actual fact, we'll be more ready after the current developments that have assisted us in being more enthusiastic and more focused. The prize for us is very simple. We have a mandate to deliver, and given the fact that we're the first to fire the salvo, we had no option but to be ready all the time. Now, of significance for all and sundry to appreciate the state of our readiness is to also appreciate that which we had to do. We just had a practical task to do, and that practical critical task is we had to deal with the basic, clear-eyed, earthbound, very practical terms of reference that underpin this commission. And let me simplify them in line with the qualification of the state of our readiness. The first term of reference of this commission is the rationale. Now, if you look at the rationale as a main river, appreciate that there are tributaries that flow into it. And the first tributary is, what was the origins? What's that which cultivated our government, the Department of Defense, to pursue the strategic defense procurement packages? And from now on, Chairperson, permit me to qualify them as the SDP packages. What was the origin that motivated our government, the Department of Defense, to pursue the SDP packages? Second to that first tributary is another tributary as to what was the reason why we pursue the SDP packages. Following up on that tributary is whether was the process legitimate, was it lawful, was it justified, was it rationally related to a very important goal in as far as the SDP packages are concerned. I assure you, Chairperson, that with this practical analogy, be better informed that we were ready, more than ready. What simplified the process also was not the material that we gathered, but it was what you mentioned, consultation with the witnesses. And I would like to extend our heartwarm and generous gesture we received from the Department of Defense in providing us with witnesses that we identified. The Department of Defense provided us with 10 witnesses. And what excited us is the genuineness on their part to demonstrate that they want a lasting solution to the cloud that is hanging over the subject of the SDP packages is the type of witness and the disposition of this witness that they provided us. Chairperson, they provided us admirals in as far as the Navy is concerned. For the edification of those who do not know, at the highest echelon of the Defense Force in as far as the Navy is concerned is admirals. I think that speaks for itself that we're provided with admirals, decision makers. In as far as the Air Force is concerned, we're provided with the generals. In as far as the Defense Force is concerned, on the side of the Air Force, the top echelons are generals. More significantly, let me recapitulate. We managed to even consult with the chief of the SANDF, General Shoke, who has been of so much assistance in laying the foundation and the pillar of our consultations. Now, this mirrors into a number of factors that we need to put on record in as far as our preparation is concerned. We did not consult in the abstract. We consulted with witnesses who are better qualified to educate us, who are better qualified to simplify the process of the documentation that we went through, and who are better qualified to make us understand the origins, to make us appreciate the reasons, more significantly, to make us appreciate the processes of the SDP packages. Now, at this stage, I'm a little bit less thirsty and less tempted to mention the number of witnesses in precision we consulted with. But initially, we were provided with 10 witnesses. Now, underpinning that testimony, Chairperson, is to positively address the processes as to where we started with the SDP packages, and we have them. Underpinning that testimony is to address the utilization and the use of these equipment that we acquired through the SDP packages. Now, at this stage, Chair, I've got to shed light and bring fresh awareness about the importance of appreciating our task at this stage. Now, you'd appreciate it better if the subject of the rationale is looked at in this context and content. After acquiring this arms and equipment through the SDP package, the real nub why we are here is to address the following question. Are we utilizing them for the purpose for which they were acquired? Now, that would be the second term of reference that these 10 witnesses we identified will be dealing with. The arms and equipment, these capabilities that we acquired through the SDP packages, are they being utilized or underutilized for the purpose for which they were acquired? Chair, these witnesses we consulted with gave it to us. Let me leave a little bit.
If I understand you, you are ready, you have consulted with those witnesses, and you are certain that they will assist the Commission to carry out its mandate.
I can address it more positively than what we have said, but permit me to close by saying the following to you, Chair. There's been a number of developments, and having consulted amongst the other witnesses with the Navy, I've learned to appreciate how they operate. They deal with ships, submarines, corvettes that are part of this SDP package. But there's a say by a famous person who liked the Navy called Larry Julian. Larry Julian says, a ship that turns its direction by 1 degree alters its course by 100 miles. We are on course, Chair, and nothing will change our direction. We are ready. I thank you.
Thanks a lot, Advocate Lebala. I think now this brings me to another issue which I think, we need to resolve today. And it's an issue which relates to the first 11 witnesses that we subpoenaed. Those will be 5 from the Navy and 6 from the Air Force. Because in terms of the subpoenas, they were supposed to appear today. Thank you. I am told that if at all they don't appear today and nothing happens today because we are not correct, the summonses might lapse. If the summonses lapse, then it means that we must start all over again to issue subpoenas against them, to issue subpoenas to be served on those 11 officials. I was also told that the Department of Defense have got legal representation, and I wonder whether we can hear from the legal representatives of the Department of Defense whether they'll be prepared to waive the fact that the subpoenas will lapse if the Commission is not correct today. If you told the legal representatives of the Department of Defense are prepared to waive that requirement, then that might make it possible for us to postpone until next week Monday, which is the 12th of August, because I was made to understand that the legal difficulties or technicalities, the President should be in a position to deal with them in the coming few days. Our desire as commissioners is that we should be in a position to adjourn this matter to the 12th of August. It was a much longer delay. In our view, it will not be to the good of the Commission. If at all there are any legal advocate Abubakar, are there any legal representatives from the Department of Defense who can deal with the 2 issues that I've raised?
Yes, Mr. Chairman. Advocate Cooper represents the Department of Defense. I think he's going to speak now.
If I may, Mr. Chairman, put on record the team representing the Department of Defense My surname is Cooper, initial M. I appeared today together with my learned friend Miss Kane, and we are instructed by Mr. Miles Carter, a director of the firm Bowman Gilfillan. Mr. Chairman, if I may address some of the matters that you have raised and that my learned friend Mr. Labalo has raised. In regard to the question of the incoracy of the Commission at this time, it was believed necessary from our point of view and for the benefit of the Commission Chairman and Commissioner to consider the point of the incoracy. Of course, I understand you would have done so in any event, but that was the purpose of sending through the application to which you have referred and which, as you know, is a draft application. It was a draft, Mr. Chair, because we required the final authority of the Minister to have moved any court application. And the Minister, having considered the matter, has directed us to make it clear that she has complete confidence in you, Chair, and in your co-commissioner to address the matter on your own initiative, and that it would be unnecessary, therefore, to pursue any court application. And of course, I am happy to be able to say that following your own remarks, Chair, the matter will be addressed in the ordinary course and will not require any other form of intervention. Because that is the Minister's attitude, Mr. Chair, we can also assure you that there would be no objection in regard to summonses which have been issued on witnesses. We would regard them as remaining in force, and the question of incoracy would not, as far as we are concerned, have any effect on them. So, Mr. Chair, the position of the Department of Defence is to support the course of action which you, Chair, have pointed out. I may add that there is no confusion on the side of the legal team representing the Department as to the primary role of the evidence leaders and the exclusive role of the evidence leaders in the preparation of witness statements and in the leading of witnesses. You indeed have no fear, Mr. Chair, that we will trespass upon their jurisdiction. We will support them. We will attempt to assist them so far as we can, but we recognize absolutely their particular jurisdiction. And I may go further and say that we have, if we may, complete confidence in my learned friend Mr. Labalo's work and preparation together with his team led by Mr. Abu Bakr. There is, however, one matter on which we are not completely in accord with our learned friends and which I would wish to raise, Mr. Chair, for you and your co-commissioners' consideration regarding the suggestion that the matter stand until, I think, approximately a week. That was to enable coracy to be re-established. But there remain two matters which the Department is anxious should be addressed in consultation with the evidence leading team. There are two matters, one of which I want to address here, one of which I want no more than to mention. The matter which I want no more than to mention is to enable the Department to satisfy itself and to satisfy the legal team that aspects of natural justice have been met in regard to the witnesses to be called. I don't want to develop that side of it, Mr. Chairman, to you in this gathering now. It is a matter which I am sure we can resolve with the legal team. But the matter that I do want to raise, both with the legal team but with you, Mr. Chair, and your co-commissioner, is the question of documentation. You will know that there are considerable difficulties which attach to the production of documentation for the purpose of the Commission. Those difficulties arise from the legislation which is in place in regard to classification of documents and the various forms and gradations of security documents. In that regard, it is essential that some format be arranged which will allow the evidence-leading team to produce with confidence and without objection the train of documentation that that team regards as necessary for the ventilation of the issues in this matter. It would be most unfortunate if there is disagreement between the department, or indeed any state department, and the team as to whether particular documents are capable of production without various precautionary matters taken, and indeed whether they are capable of production at all in the absence of declassification or in the light of the status of particular documents. That interchange between the department and the legal team has not yet resulted in a resolution which will permit the optimal use of the Commission's time once evidence is led, and will permit the department and its legal advisors to have assured themselves that they are not party to any infringement of statutory requirements. I have no doubt such a resolution can be reached, but it seems to me unlikely that we can reach it within the period of 1 week. It involves, Mr. Chair, not only a modus vivendi in regard to the production of documents, it involves the question of the declassification of documents, which is a process that has not yet been completed. And so, Chair, I would ask you and your co-commissioner to consider, at our request, an adjournment not of 1 week, but of 2 weeks. Thank you, Mr. Chair.
The 19th.
I think this question of classification of documents has always been a nightmare. I mean, together with our evidence leaders, we spend a lot of time looking at that question. And I'm not quite sure if we have resolved it even in our own minds. I've just spoken to my co-commissioner here, and we believe that if at all the legal representatives of the Department of Defense requires a period of 2 weeks within which to try and deal with the question of declassification of documents, this might be a very helpful suggestion. I suspect that it will even stop the question of us calling a witness after every 15 minutes, asking members of the public to go out so that we can deal with that question. And in my view, which is supported by my co-commissioner, we do not think that an adjournment of a period of 2 weeks is unreasonable. And I think we will agree to adjourn the public hearings until the 19th of August. But then that is subject to parties understanding that at the moment we are not correct. What we are doing is that if at all somebody wants to raise the argument that we cannot postpone this matter or we cannot adjourn these proceedings to the 19th because we are not correct, then what I'm telling you now that is a wish to adjourn the proceedings until the 19th. As soon as we are correct, then I'll issue that type of an order saying that, you know, the proceedings are adjourned until the 19th of August. And I think I should also thank the team from legal advisors of the Department of Defense for the attitude that they seem to have displayed up to now. And I think with proper cooperation between the two legal teams and the witnesses, that will make it much easier for the Commission, for the Commission to carry out its mandate. I think for present purposes, that will be the end of the proceedings, and I hope that, you know, on the 19th we'll be correct and we'll be in a position to start with the first witnesses. And then, too, I'm going to make a suggestion that, seeing that, you know, our evidence leaders knows already who are the legal teams of the various parties, probably Advocate Abu Baker, that pre-trial conference that we had in mind, you can start looking at it within the coming 2 weeks and just make sure that all those small things are sifted and attended to so that come the 9th and then, you know, all those small issues do not stand on our way.
Mr. Chairman, we have no doubt that Mr. Cooper and his team will fully cooperate with the team of evidence leaders. We are quite satisfied after having talked to him this morning that there will be full cooperation from the Department of Defense. What Mr. Cooper has not done, though, is address the question of the subpoenas and perhaps give you, Mr. Chairman, an assurance.
Advocate Abu Baker, if I'm not wrong, I think I heard him loud and clear when he made that point. I made a big write on my notepad because that was one of the things that was worrying me. He has given that undertaking. I suppose sitting behind you, let me not talk for him. If I'm wrong, he'll say so.
You're quite right, Mr. Chairman.
Thank you.
Chair, there's one more thing that I want to place on record, and that is there's going to be a short meeting in the next 20 minutes in the boardroom where the evidence leaders will meet with the legal teams to iron out what the future will hold. That is not the pre-trial conference which we had in mind, but simply to iron out housekeeping matters. So please, if every legal team here would make their way in 20 minutes' time to the boardroom so we can talk to them.
I suppose the same thing will apply to the legal teams of DTI and Trade and Industry, because I'm sorry, DTI and Treasury, thank you. Because I know that they have legal teams, and the legal teams also came in a bit late into the picture. Probably if they also attend that meeting, it will make our life much easier. But then otherwise, when and how do you meet, we leave that to the evidence leaders.
Yes, Mr. Chairman, what was intended was all legal teams. All legal teams should attend that meeting.
All legal teams should attend that conference. Oh.
Yes.
Thank you. Then we adjourn to the 19th of August this year, and hearings will take place again at the same venue. Thank you.
Well, there you have it, Judge Sariti confirming the information we had earlier on that indeed the commission would be postponed. So issues being raised that in the light of the resignation of Judge Lekhodi, whether in fact the two judges constitute do have a quorum. So the president, according to the judge, needs something between 2 and 4 days to consider this matter. By the end of the week, the president will then express his view about how it is hoped that this commission will continue. Well, Advocate Abu Bakr, the evidence leader, raising the issue of tactical difficulties following this, the view that has been expressed as to whether the two judges constitute a quorum. But of course, all the teams underlining the fact that they were fully prepared. In other words, it is not because of them that this commission is now being postponed. But of course, there's also going to be a meeting of all the legal teams to iron out. As it turns out, there are outstanding issues, and among those issues is the issue of the classification of certain documents. They hope to iron those out, and that in part influenced the decision to postpone by 2 weeks, because they need the 2 weeks to iron out some of those outstanding matters. Well, from us here at the St. Mark's Square in Pretoria, it's a very goodbye, and we're going to hand over to Lorette back in the studio.